Welcome everyone. Good morning. Mark Pinto here at Phoenixville Public Library, welcoming you to Legal Aid's presentation of landlord tenant law and the coronavirus. Everyone should be muted during this presentation. Make sure that's happening. You are welcome to unmute yourself to ask any questions during the presentation, and you can do that by holding your finger on the space bar on your computer, or you can ask your question via the chat feature as well. Okay, I think we're ready to start. So Christina, please take it away.
Great. Thank you, Mark. And thank you to the library system for inviting us and for this opportunity. My name's Christina Drzal. I work for Legal Aid of Southeastern Pennsylvania. Today I'm going to be talking about sort of the basics of landlord-tenant law and the coronavirus, how these two are intersecting with the idea that, legal aid fights evictions and how to help yourself and how to know when you have an issue. A little bit about me. I am the supervisor of a regional housing unit for Legal Aid. We handle all housing issues, foreclosures, evictions, everything related to housing. I've been a practicing attorney for about 13 years now. The first 10 years I did landlord-tenant, and now I'm doing landlord-tenant and homeownership foreclosure. Hopefully you are all familiar with Legal Aid, but if you are not, we provide free legal services to low-income clients in Bucks, Montgomery, Delaware, and Chester counties. I work in all 4 counties, although my office is located in Chester City. Our practice areas are family law, domestic violence, housing, bankruptcy and consumer law, unemployment compensation, public benefits, Social Security, dependency, expungements, and elder law. Before I get started sort of in the details of the law, I'd like to take a few minutes to discuss sort of the who and the why. Who do evictions impact and why do we talk about this? Why is Legal Aid concerned? The statistics that I'm going to go over in this slide are from Princeton University's Eviction Lab and from Matthew Desmond's book, Evicted, a really great book since we're dealing with the library. Won the Pulitzer, I think, in 2017. I highly recommend. But what these sources of information tell us is that an estimated 2.3 million evictions were filed in America in 2016. That's about 6,300 people being evicted every day. That was roughly 1 eviction filing for every 17 renter households between 2000 and 2016. I see this all the time, but most poor renting families spend at least half of their income on housing costs. Poor people spend more money to stay housed, with at least one of those families spending over 70% of their income just on rent and utilities. Evictions particularly impact low-income women, especially poor women of color, have the higher rates of evictions. So Legal Aid focuses on housing and evictions because we see that housing is really at the intersection of poverty, racial equality, and gender equality, all things that we would be concerned about. And I would just say, in relation to COVID, all of these statistics, first of all, are underreported. There's no national database on evictions. Every court system shares their information differently. For example, most evictions are sealed in California, so these numbers are very low. We know that with the coronavirus, unemployment has tripled. So we expect these numbers to get much worse. So part of that is trying to educate people and trying to get people to assert their rights in court. So that's what we're going to review today. The first step is, how do evictions happen in Pennsylvania? I'm going to start by saying this is how evictions happens. This chart relates to how evictions happen in Pennsylvania in MDJ courts. Most evictions happen through the MDJ courts. That's the Magisterial District Justice, because that is the lowest court. That is the easiest court to get into. That is the cheapest court. You don't necessarily have to hire an attorney. So this is about evictions in MDJ court. You can file an eviction in the Court of Common Pleas, which is the next highest court up, but most people do not file evictions. Most landlords do not file evictions in that court because it takes longer, it's more expensive, and legally it's more complicated. So most evictions you see will happen according to this chart in the magisterial district courts. So the first step for an eviction is that the landlord would give you a notice to quit. Right? A notice to quit is just a formal legal term to say the landlord's telling you that they want you out, right? They're saying, I want you to pay because you haven't paid rent. I want you to leave because you damaged, whatever. The notice to quit is their notice that they want you to leave. The catch is the notice to quit can be waived in the lease. So when you signed your lease, you could have signed something that says, it's okay for you to evict me without sending me a notice to quit. So not everybody gets the notice to quit, but most people do, and that's generally the first step. The second step is that the landlord would file a complaint. A complaint is just another word for a lawsuit, right? The landlord would fill in a one-page fill-in-the-blank form. It's very simple, stating what they want, what their claim is, how much they're asking for, if they're asking for possession, and that's the lawsuit. Once the landlord files the complaint, the law requires that a hearing be scheduled 7 to 15 days later for the hearing. Next, the tenant has to get notice of the court hearing, right? The tenant is required to get notice of the court hearing at least 5 days prior to the hearing to give the give the tenant notice to prepare and time to prepare their defense. So the tenant would get a notice of the complaint and a notice of the lawsuit. Typically, this is done either by the sheriff or through posting of the property. Next is the hearing. This is a hearing before the MDJ, the Magisterial District Court. There's many MDJ courts. This is not the big courthouse in the Westchester County seat. These are the small little courthouses. Some people think of them as small claims courts. There's about 25 different ones in each county. They're generally very informal. The MDJ, the judge, will say to the landlord, what do you want? Say to the tenant, what's going on? It's not a formal process like you would see on TV with as many objections or defenses. It is a court, so they have those things, but most MDJs keep their hearings very informal, and many people represent themselves. After the hearing, the judge makes a judgment, right? This is the judge's decision. What is their order, the outcome of the case? The judge has 1 to 3 days to make their decision. After the judge makes their decision, there's a 10-day period that the landlord must wait. That's the appeal period. After that 10 days, the landlord can go back to the MDJ court and ask for an order of possession, right? That's the order saying that the landlord can take the property back. That order of possession is served on the tenant by the constable. They'll send a piece of paper to the door, and that will let you know when the constable or the sheriff is coming to evict. It's typically 10 days later, but it will let you know, it'll be written in the notice. So this is the timeline from start to beginning. Illegal evictions. What are illegal evictions? Illegal evictions are all the things that don't follow that process that I just described. An illegal eviction would be when a landlord tries to force you out by throwing your belongings out, or turning off the utilities, or trying to take your doors or windows off, or somehow try to get you out of the property without going through the court process. Pennsylvania law requires that landlords may only evict by valid court order. The law also requires that evictions are executed, right? They're done by the sheriff or the constable. So if you are being evicted, it shouldn't be the landlord. It should be the sheriff or the constable that's coming to evict you. If you think that you are being evicted, or if you think that you are illegally being evicted, What can you do? Legal aid first requires call the police, right? Say to the police, I'm a tenant and this landlord is trying to illegally evict me. And sometimes the police will get involved. You can call legal aid. We can file an injunctive lawsuit for you to request an order from the court that requires the landlord to open the door to you. You can also call the Attorney General's office, and I list the number there. The Attorney General, Josh Shapiro, has taken a real interest to illegal lockout cases during the coronavirus, right? We understand that landlords are in a tough situation if they're not getting rent, but the law still requires that they go to court. So the Attorney General is taking an active stance to get involved and will talk to landlords and who are trying to do illegal lockouts. How do you protect yourself from these situations? If you're not sure if you're being illegally locked out, if you think maybe my landlord might do this to you, keep proof of tenancy outside of your home, right? Proof of tenancy is a copy of your lease, a copy of your rent receipts, maybe a utility bill with your name at that address. Those are all proof that you are a tenant and that you have the rights and protections of a tenant. So you want to keep that proof in your car or with a trusted neighbor, because what you don't want is to be illegally locked out and not have any proof to show to the court or show to the police that you are in fact a tenant. So that's a step that you can take to protect yourself. Why can a landlord evict? There are 3 reasons. The tenant doesn't pay rent. The tenant commits a lease violation of an oral or a written lease, or the lease term has ended. Those are pretty much the only reasons. One thing to note here is an oral lease is valid in Pennsylvania. You could have an agreement with your landlord. Hey, I'm gonna rent this apartment and I'm gonna pay you $1,000 a month. And that be it. That's an oral lease contract. If you're paying and they're accepting the money and you are living there, a lease does not have to be in writing to be enforceable. PA recognizes oral leases. So these are the reasons that you can be evicted. Why can't a landlord evict? These are typically the discriminatory things that we would all assume. You can't evict somebody because they're disabled, because of their race, because of their gender, color, national origin, religion, family status. That's usually having kids. These are all federally protected and reasons that people cannot be evicted. In addition, Pennsylvania law has extra protections. You can't, under Pennsylvania law, evict someone because they're older, right? 40 and above. We have some age protections, as well as local municipalities often have their own ordinances. For example, I live in Delaware County, and Swarthmore and Springfield both prohibit discrimination in housing based on sexual orientation and gender identity. So sometimes your local township will have added protections in addition to the federal or state protections. If you are disabled and living in housing, one way that we often assist people is by requesting a reasonable accommodation, right? If you are disabled, you can request a reasonable accommodation, which is a change or exception to the lease term or landlord's policy or practice to accommodate tenants' disability, right? We want to make housing equally accessible to people who are disabled. So if you can make a request, a reasonable accommodation request to your landlord, they may be required to accommodate those requests. For example, I have a client who's disabled, so our reasonable accommodation request and used a wheelchair. So the request to the landlord was, we need a designated parking space closer to the entrance to the unit because she has difficulty moving around with her wheelchair. So that's a reasonable request, and the landlord can designate a parking space for her closer to the door. What would not be reasonable would probably be to ask the landlord to install an elevator because that's very expensive. So cost can be a factor as well. But reasonable accommodations are great ways You do not have to do anything formal or fill out any form. You just write a written request to your landlord about accommodation, stating you're disabled and making your request for whatever accommodation you need. And we oftentimes help people in writing these requests and getting them fulfilled with landlords at Legal Aid, but we also work with many other organizations that do the same thing. So this is a great tool for people who are disabled and trying to keep their housing. Post judgment. So this is what happens after the landlord tenant hearing. After the judge makes their decision and has a judgment, what goes next? The judge makes the decision, and as I said, there are two ways to appeal. You can have a 10-day appeal or a 30-day appeal. And these timelines go from the date of the judgment, right? The date that the judge entered their order. So in Pennsylvania, if you file an appeal, it has to be a written appeal to the Court of Common Pleas, the next court up, within 10 days. And if you can pay either the monthly rent or the bond and the appeal fee, you can stay in the property while the appeal is pending. So for many tenants, this is a great relief. Maybe they didn't do so well at the MDJ hearing. Now they want to take a second shot on it. If you can appeal within 10 days and pay these fees, you do not have to worry, you can stay in the property. The appeal fee is about $300. But you can file a fee waiver application with the court. And if you are low income and the court waives the fee, you would not have to pay that. You do need to pay your monthly rent into the court escrow, right? So if the MDJ says your rent is $700, you have to pay your rent into the court escrow every month on time, or you would not be able to stay in the property while the appeal is pending. You also have to pay a bond. The bond is either the amount of the judgment or it's 3 months rent. But if the tenant is low income or on Section 8, you can fill out an affidavit so that you don't have to pay the bond. So at a minimum, the minimum cost for filing the appeal would be you have to pay your monthly rent into the court escrow to stay in the appeal. And the appeal hearing can be many, many months later. In Delaware County, it's 9 months later. I think in Chester County, it's not that long, but it's usually many months after the MDJ hearing, which gives people more time to sort of figure out what their next step is. So that's the most, we help people with appeals, and most people are interested in the 10-day appeal because they need to stay in their apartment while they figure out their next move. If you're not interested in staying in the apartment while the appeal is pending, you can file a 30-day appeal. Then you just have to pay the appeal fee or get it waived, but you have to move out while the appeal is pending. One thing allowed by Pennsylvania law is pay and stay. If the eviction is for non-payment of rent only, a tenant can pay what they owe with court costs prior to the eviction and stay. So if your landlord sued you just for non-payment of rent and they're not suing you for damages or anything like that, if you can get the judge allows it, you can get the money together and pay the constable prior to the eviction to stop the eviction. One thing to consider in all of this, and I think that impacts my clients greatly, is that judgments are garnishable, right? It's a judgment, so I think they can take up to 10% of your wages. If they go through that process, which is a whole other process and many landlords do not, but it's potentially possible they could garnish your wages. It's also a public record. It's very easy to look up landlord-tenant judgments, and many landlords do when they're renting to people. So if you have a recent landlord-tenant eviction record and you're looking for housing, it often is much more difficult because the public record is so easy to access. It can also impact your credit rating if you have a negative landlord-tenant judgment. So these are all things to keep in mind. Of course, legal aid represents people in these matters and negotiates those outcomes.
Christina, a question came in on the chat.
Sure. I don't think I can see it. Can you?
Okay, I'll read it to you.
Thank you.
Question is, what happens if the tenant does not pay the rent into escrow during the appeal process?
That's a great question. So what happens depends on what the plaintiff does. You could not pay anything into the court escrow, and if the landlord or the landlord's attorney, the plaintiff does nothing, you would be fine until the appeal hearing. But if the landlord is experienced or the landlord has an attorney, if I was an attorney representing a landlord and the escrow was not being paid, the landlord can file a precipice, which is, it's just a piece of paper with the court to say, terminate the tenant's right to stay in the property while the appeal is pending because they haven't paid the escrow. So essentially the plaintiff can ask that you be evicted, and it's not even, there's not even a hearing, right? They just basically file a piece of paper with the court. The court checks that the money isn't there and the court says, fine, you can go get the order of possession. So if you're not paying, the plaintiff has a very easy and quick avenue to get you evicted. All right. Coronavirus protections. How have evictions changed? What impact has the coronavirus had on this process? I see another question coming up to me. I don't know if that's related. Hold on. Well, I'll just go ahead and Mark can interrupt me. All right.
Okay, I can, yeah. Part of the question got cut off, I think at the beginning, is does the tenant have to appeal or can the lawyer do it for her? She has already had one hearing in Westchester at the courthouse.
I didn't understand it. Does
the tenant have to appeal or can the lawyer do it for her?
The lawyer can, if you're talking about can the lawyer appeal for you from the MDJ to Court of Common Pleas? Yes, attorneys can file anything. If they're representing you, they can file the appeal for you. Absolutely. Tenant or attorneys can act as clients in court, so that shouldn't be a problem. On July 2nd, Pennsylvania's Governor Tom Wolf announced he had previously announced an eviction and foreclosure moratorium, and he announced the extension. So the eviction and foreclosure moratorium is now good through August 31st. In Pennsylvania, you cannot evict or foreclose, file new evictions or foreclosure actions until that time. There are a few catches. This applies only to non-payment or end of lease term cases, right? If your lease is up or you haven't paid your rent, this can apply to you. If your landlord is evicting you because you've damaged the property or for criminal activity or anything like that, the governor's moratorium would not apply in those cases. The governor's protections may not apply if the foreclosure or eviction was started before March 18th, essentially before the coronavirus, because Governor Wolf's order really is about protecting new evictions and foreclosures that started after the coronavirus and is not really meant for cases that were started pre-coronavirus and that are unrelated. So those cases may not be protected. You may not be protected also if you waived the notice to quit in the lease, right? So when I talked about signing your lease, sometimes your lease says, I waive the notice to quit. If you come to evict me, you don't have to tell me and send me the notice to quit. If you waive that right, the governor's moratorium may not apply to you. All right. In addition, so that's, I would say, the biggest protection that's currently pending, as well as back in March, the federal government passed the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act. This act, the protections for tenants expire in 2 days. So even though that seems like it wouldn't be relevant, I do want to go over it because a lot of the protections will continue and tenants can enforce against their landlords. So the eviction protections expire in 2 days, but this is what they cover. It prevents the filing of new evictions for certain properties for non-payment of rent. So similarly to Governor Wolf's order, if you are being evicted for something else like damages, this would not apply to you. The CARES Act, the properties that are protected are generally subsidized programs, right? If you have a Section 8, public housing, low-income housing tax credit, any of those programs where the government is paying part of your rent, you would be protected. Also protected are properties with federally backed mortgage loans. What does that mean? The owner of the property has a loan that's insured by the government, right? So an FHA loan, Fannie or Freddie loan, Fannie or Freddie Mac loan, a VA loan, rural development loan, all of these loans where the government comes and insures you, that is also covered under this act. And what this act prohibits is between the March 27th date and July 24th, you can't charge fees, penalties, or other extra charges to the tenant for non-payment of rent. Why is my next one not going?
I have another question on the chat.
Sure, go for it.
Okay, she says, I wasn't evicted, but does the coronavirus allow any room as far as moving out? We intended to move out on April 1st, but it took us a few extra days to get everything out. Our landlord kept most of our security deposit and lied for the list of reasons which I have proof of. Can I take her to court for the rest of my deposit?
Sure, you can take her to court. The question is, would you win, right? And a lot of that have to do as to, you can certainly file a civil complaint with the MDJ. There's a link on my last slide to the court's website. It's an easy fill in the blank form. So most definitely you can sue your landlord, and there are provisions in the law that if your landlord has incorrectly, well, if we have time, I'm gonna go over security deposits at the end. But to answer your question quickly, yes, you can sue them. Whether or not you would win depends on what your lease says, right? How are you supposed to terminate your lease? What notice are you supposed to give? When are you supposed to be out? So I couldn't really sort of generally answer that question without seeing your lease. And I will try to, if we have time, I have a slide on security deposits, so I'll try to go through that as well. If not, it'll be in my slides, which you can look at, and it has all the links. All right, so what other protections are under the CARES Act? It requires landlords that get forbearances, landlords that get a break from the government need to give equal protections to their tenants. It also requires that when these protections expire, that the landlord gives 30 days notice to evict. So even though this part of the law is expiring in 2 days, the landlord would still need to give 30 days notice from 2 days from now. So these are protections that are out there. Now, those protections, if you have Section 8, if you live in public housing, it's pretty easy to recognize that you are covered under the CARES Act. But the CARES Act also protects people who rent from landlords with federally backed mortgages. When I think to when I was a renter, I had no idea what type of mortgage my landlord had, right? I would have no idea if it was federally backed or not. And I doubt most landlords are going to tell you or let you know or show you a copy of their mortgage, right? That's a protection, but it's a protection that most people don't know that they have. To fix this problem, just recently on July 16th, the Pennsylvania Supreme Court entered an order which requires landlords, when they sue for eviction, to complete an affidavit of compliance. So basically what this affidavit is saying is whether or not those CARES Act protections apply to you. So if you are being evicted, you should also receive this extra affidavit and be able to check it to see if you would be covered or have extra protections. All right. Also related to the coronavirus, the Pennsylvania State Legislature just recently passed the rent relief, the CARES rent relief program, right? The federal government gave Pennsylvania a bunch of money. Thankfully, Pennsylvania has decided to use $150 million of this to assist people in paying their rent who are affected by COVID. So this is actually a wonderful thing. And I'm going to tell you a little bit about this program. There are obviously, because the government has designed it, there's a lot of hoops to jump through, but there's a possibility that this could help people avoid eviction. So like I said, there's 150 million available for rent assistance. There's 25 million for foreclosure assistance. To get this money from the state, you have to have been affected by COVID-19. The deadline to apply is September 30th, so it's very quick. Applications can be found at phfa.org, PA Cares, it's right there. The maximum grant is $750, so they will only pay $750 a month in rent for up to 6 months, so $4,500. Who can get this money, right? Who can apply? Renters or landlords can apply. These are the income qualifications. The renter's total household income can't exceed the median area income for their county. For Chester County, and for actually all 4 counties that I work in, for a family of 4, that's about 96,000. So that's fairly high. The renter, and so you have to meet this median area income, and you have to document a 30% reduction in your income due to COVID after March 1st, or you became unemployed, right? So it's an either or. So you have to show some impact. What documentation? It's a 3-part application. Both the tenant and the landlord have to do the application together. You have to show proof of your lease. Oral leases are okay. They will just have you fill out some sort of attestation. Third-party address verification, right? Utility bill at that address, something like that. Proof of income. Proof landlord owns the property. And then the landlord will have to sign some paperwork saying that their property is up to date and that they've paid their taxes. The catch, and I think the difficulty about this program, one is that the cap is $750. As I know from experience, the rates for renting housing, especially outside of Philadelphia, $750 is a little low, right? That's not going to cover most rents. So for many people, that's not going to be able to cover their arrears. In addition, in order to receive the funds, the landlord must agree to waive any obligation of tenant to pay any past or future rent for months when the funds are received. So if the landlord gets $750 for February, the landlord can't charge you anything else for February. You'd have to waive everything else. The landlord must also agree to hold off on eviction proceedings for 60 days from the date rent was due within the last month assistance was provided, right? So essentially they have to hold off on evicting you for 60 days from the date that they get paid. So those are tough caveats. I know many, we've spoken to landlords, many landlords are not going to agree to those terms, but there is it's a grant, it's free money, you don't have to pay it back. So if you know somebody who can qualify, we'd highly recommend that you apply. Let's see how much time I have. Okay, we have plenty of time. Another issue that I see in landlord-tenant law and that we litigate constantly is repairs. The most common scenario when I have someone coming to me saying that they're being evicted is, oh yeah, but you know what? I've had this problem in my unit for many, many months. So repairs are oftentimes intertwined with evictions. My first piece of advice is document, document, document. Oftentimes people will come to me and they're at the end of their rope. They're saying, I've talked to my landlord for 3 months and we haven't had hot water and I'm tired of it. I want to sue. And then I'll ask them, well, what documentation do you have? Do you have a letter to the landlord stating what the problem is? Do you have text messages? What does your lease say? How are you supposed to tell them? Because ultimately, if you end up in court, you need documentation to prove your case. So oftentimes when clients come to me, a big part of what I do is helping them to formally write the letters, keeping a copy, sending it traceable, making sure that if you want to take someone to court, that you have evidence to try your case on. So document is my first piece of advice. Next, in Pennsylvania, the law has an implied warranty of habitability. The law requires that the landlord must provide safe and sanitary conditions. And this is in a Supreme Court case, Pugh v. Holmes, which is linked there. What this means is, you know, it used to be when we rented property, when we were an agrarian society, that people rented property because they wanted to farm. So nobody cared about the structures or the buildings, and everything was as is. But as we became more developed or moved into cities more, we realized that people are renting for the building and not for the land. So in recognition of this, the PA Supreme Court said that in every residential lease agreement, there's an implied warranty of habitability. The landlord is required to keep it safe and sanitary. Even if the lease says as is, that's not enforceable. Even if the landlord says, you know, you take this as is, we're not going to do anything. The PA Supreme Court says we do not allow this. This is required for every lease contract. So this is an important case, and I oftentimes recommend, even if, you know, take a look at it. What are the solutions if you have a repair issue? We have about 6 solutions listed here. The first one is you can complain to code enforcement, right? Or your local health department. Every municipality or township has somebody enforcing their code. You can go to complain to them. The caveat is the government has the power to condemn, right? So if your property is so bad that the city may condemn it, the city, if they condemn it, can require you to leave the property, you know, in 24 hours or 3 days or a short period of time. So the double-edged sword of calling code enforcement is that the property could get shut down. Another solution is repair and deduct. If you have a minor problem, you can send a notice to your landlord saying, hey, the toilet hasn't been working for a month. Can you come fix it? And if the landlord doesn't respond, you can send another letter saying, okay, I got 3 estimates. Here they are. It's going to cost $500 to fix the toilet. I'm going to take that out of my next rent payment, and then I'll pay you the $200 difference. And then you would send the remainder of your rent, the rent receipt, and everything to the landlord, and then continue paying your rent for the following months. Another possible solution is escrowing your rent. You can set up an escrow account, provided you've given your landlord written notice, you've given them a reasonable amount of time to make the repair. If they still refuse, you can send a letter saying that you're going to escrow your rent, and you would put your rent into an escrow account at the first of every month in full and on time to try to leverage against your landlord and force them to make the repairs and or take you to court to have the judge decide. If the repair issue is big enough, you can terminate your lease, provide written notice, and move out possibly. You could sue your landlord for damages, right? I didn't have heat all winter and I had to use space heaters and my electric bill went up by 20%. So I'm going to bring that proof to the court. I'm going to sue you for damages. You can also sue for specific performance. That's requiring the landlord to actually do something, but I've never seen this happen in court because judges rarely enforce hearings that way, but technically it's an option. I bring to everyone's attention the Rule 508. You don't have to remember the rule, but essentially what this rule says is that at any time before the hearing, the defendant may file a cross complaint asserting any claim against the plaintiff which arises out of the occupancy of the premises without paying a filing fee. So if you're sued in eviction court and you have a claim against your landlord, you can file a cross lawsuit for free as long as you do it prior to the hearing. So oftentimes, if I have clients with good cross claims, then I will help them to file that as well. So you can have your claims heard at the same time and have a little pushback against the landlord.
Question came through on the chat. Christina, what if the tenant creates the unsafe/uninhabitable conditions?
Then you can't sue your landlord for it, right? I mean, you could, but that would be crazy. If the tenant creates the unsafe conditions, then it would be up to the tenant to repair those. I mean, it's sort of I'm trying to think of what an example would be. If you're the tenant and you break the heater, there's no heat in the winter, then yes, you are responsible for making those repairs. I certainly wouldn't represent anybody in court to sue the landlord over damages that the tenant made.
Another comment, they added to this, tenant gets notice to evict, but then claims damages they cause.
Tenant
gets notice to evict.
So that's up to the judge to decide, right? And oftentimes in an eviction case, tenants will bring up damages, right? Because you have, prior to the eviction, tenants and landlords kind of trying to work together, and the court, everybody hates each other and throws it. So yes, if someone's making up a claim, whether it be the tenant or the landlord, that's up to the judge to decide, and that's gonna be based on the weight of your evidence, right? Have you papered things? As a landlord, have you kept copies of all your notices to the tenant? As a tenant, have you kept copies of all your landlord's complaints to the landlord? It's really an evidentiary issue, and it's up to the judge to decide who they believe. I don't know how I got to this one. Sorry. One thing I will say about the implied warranty of habitability, it's not cosmetic issues, right? Sometimes I have clients come to me, I want to withhold my rent because the place hasn't been painted in 10 years. Old paint is not a safety issue. If it's just, so it has to be a safe and sanitary condition. It cannot be a cosmetic problem as to why you would be taking these solutions. As well as, I think there has to be a proportionality consideration, right? So if I have a client who tells me I've got open sewage in my basement and it's everywhere and I want to escrow my rent, but the second and the third floors are fine, then I would say you probably want to withhold 1/3 of your rent if only 1/3 of your house is you can't use. There has to be some correlation between what's unusable and how much rent that you are withholding, as well as if the problem is my toilet doesn't work, but you can live in the rest of the house, I would say it's not reasonable to deduct your whole rent just for one small issue. So there has to be some sort of connection between how much you are withholding and how much space you can use and the extent of the problem. So those are some things to think about. How much time do I have? All right, I'm just going to touch briefly on this one. Subsidized housing and affordable housing. This is a very long topic. I could do a whole hour presentation, but I just want to highlight some of the extra rights that people in this type of housing might have. There are many different programs. Section 8, public housing, project-based vouchers, elderly and disabled housing, low-income housing, USDA. In these programs, rent is capped at 30 to 40% of the tenant's income. These tenants generally have more due process rights. They can only be evicted for good cause, except for low-income housing tax credits, and they must be evicted through the courts as well. You can also file a complaint with HUD on that link that I provide right there. I'm going to talk about security deposits because someone had an interest in that. The security deposit is a Landlord Tenant Act of 1951 is the applicable law. Security deposits can be up to 2 months rent in the first year. After the first year, it must be one month's rent. So if you've been there for more than a year, you can ask for your 1 month's security deposit back. When a tenant moves out, they must give the landlord a forwarding address for the deposit. I always say do this in writing, right? Quick letter. If you don't have a good relationship, send it certified or email or trackable, or check your lease and see what it says. Keep a copy, send it to the landlord and provide the address. The landlord has 30 days to respond. They must return the security deposit in full or give an itemized list of damages plus the difference. If the landlord fails to respond in writing within 30 days, they waive the right to sue for damages. So it's another way to see this is if you send that, you are also offering more protections against yourself if the landlord can't sue for damages. If the tenant, so as the prior person asked, if you sue the landlord and the court finds that the landlord improperly withheld the security deposit, you can recover 2 times the amount wrongly withheld. So if my security deposit is $700 and the court finds the landlord was wrong with withholding it, I can recover $1,400. Okay, so those are the security deposit issues. Resources. This is my resources page. All of these links hopefully should work if you get my PDF. The first one is my legal aid's website, last.org. That's how you would apply to become a client. We have online applications 24 hours a day. We also have a hotline if you don't have internet access. The number is 877-429-5994. It's usually open Monday through Friday from 9 to 1, but we've extended those hours during the coronavirus. So I think it's open till 3:30 now. Another really great website is palawhelp.org. It's run by legal aid organizations. There's a ton of DIY information on the law, forms, videos. You know, there I think are 20 legal aid organizations in Pennsylvania, and they've all contributed to help people help themselves. So that's a really great website. National Housing Law Project and Regional Housing Legal Services, I give their websites. They have a lot of really good information, up-to-date information on coronavirus protections. The coronavirus law is changing constantly. We had 2 changes this week, so I'm constantly updating my slides and doing this. So those are good places to check. The Housing Equality Center of PA deals primarily with discrimination. So those cases where you're just being discriminated on race, gender, sexual orientation, they take a lot of those cases. PAcourts.us forms, that's the Pennsylvania courts website. There's a lot of forms on there that you can use for the participant that wanted to sue their landlord. If you go there and you go to they have a civil complaint form, you can fill it out and file it with the MDJ to sue them. So they have fill in the blank forms there. The Pennsylvania Utility Law Project, we work with them often. Utility and housing are intertwined, right? It's hard to live in a house if you don't have heat or water. So they have a lot of great resources and information on utility moratoriums that might be currently happening. PA Housing Finance Agency, that's the agency that's running the rental and mortgage assistance. So they have a lot of information in the applications there. As well as my name, Christina Drzal, my email address and my phone number. Please feel free to reach out to me if you have any questions as well. All right. Looks like we are towards the end. I'm happy to take questions.
Feel free to unmute yourselves either through the controls or by holding your finger on the space bar.
Hello.
Hi.
Hi, I was the one that asked about the security deposit.
Sure.
I just wanted to clear up one thing before I decide to take her to court, because she did breach a lot of what it states in the security deposit aspect of our lease. It was very difficult moving out during the coronavirus, but she lied on a lot of things. So my question is, does the coronavirus give you wiggle room because we told her we would be out by the 1st, but technically we really weren't out until the 7th, and
No,
the charge, what,
no.
I'm sorry? No,
It
okay.
is not. So the risk there, and again, it's difficult for me to completely advise you without seeing your lease or without the full case, but yes, if your lease requires when you move out, typically it requires the last day of the prior month or the first day of the, it would either be July 1st or the 31st of the prior month.
Right.
And if you don't move that over, then you are a holdover tenant for those 7 days. So could the court charge you for the full month's rent for those 7 days? Yes. Will they?
Okay.
I don't know.
Now, if she breached the lease, as far as what was supposed to be done, and we did do that, if there's a breach in the lease, do I have a better chance of?
It's a little too vague. I'd have to sit down and look through your case with you. So there can be a million breaches. I have no idea. My suggestion is if you qualify for legal aid, apply and have an attorney look at your case in depth.
Okay. I don't think I do, but okay. All right. Thank you very much.
You're welcome. Any other questions?
Information was great. Thank you.
Great. I'm happy to help. Since we have a few minutes, what I've been doing, because I hate to give up my time, I'm going to show you guys how to look up, if I can get my computer to cooperate, I'm going to show you guys how to look up MDJ evictions and how to check your eviction record, because I feel like that would be useful. So just give me a second to get out of this. Sorry. Why is my link not working? I'm just going to try to copy it. Here, this is what I'll do. PA courts. All right. Where did I go with this? Sorry about this. All right. This is the website that I'm going to, this pacourts.us forms. For some reason, my link is not working, so I just typed it in myself. I'm going to show you how to look up a landlord tenant record. I'm going to actually show you how to look at the public docket, so you could look at any court case.
You need to share your
Let's see your
screen again.
screen.
Oh, I'm not sharing my screen, sorry. What did I do? I got out of it. All right, am I sharing?
Yes. We
Okay,
see your slide though from your slideshow.
Perfect. All right. So the website I'm talking about is this one I'm kind of circling right here, pacourts.us. I'm going to go to that. For some reason, my link isn't working, so I typed it in. I'm going to go there now. All right. This is the Pennsylvania Courts website. I want to teach you how to look up your court information. If you look up the top, it says case information. So you want to go to court cases. If you look, it lists the courts, magisterial district courts. That's what I was just talking about. That's where evictions occur. Philadelphia Municipal Court is the same thing, except they have a different name in Philly for whatever reason, because they're special. So it goes magisterial, and then next is common pleas, and then appellate, and then superior. So for most people, you're going to be going case information, court cases, and you're going to go to magisterial district courts and click on that. If you scroll down, so it shows you, it says magisterial district courts docket sheets. Search type. You can search by all of these features. The easiest thing to search by is the participant name, right? But if you had the date filed or the docket number, you could look at all those things. Most people don't, so I just say look at the participant name. I'm gonna look up someone, an easy name. All right, Frank Jones. So I'm gonna put Jones here and Frank. You need one other factor. You could pick a county, right? So you could pick Chester County. If I pick Chester and I hit search, I would see no cases against Frank Jones in Chester County. But if I chose, let's say I chose the type, if there's different types of cases, civil, criminal, landlord, tenant, traffic. Let's say if I did Frank Jones and landlord, tenant, and then I hit search. So this is not in Chester County. This is all Frank Jones in Pennsylvania, MDJ, landlord, tenant, and I hit search. See, I did this before, so it should work out. So I see all these Frank Jones cases, but it's a common name. So how do I know which one's mine? I'm going to check on one of these. You can click on the docket sheet on the left. For Frank Jones, not my client, to be very clear, just somebody I randomly found. So this is the docket sheet. This tells you what happens in Frank Jones's case. It looks like Bogart Properties sued him. The disposition date, that's the judge's decision date, right? So if you were appealing, you would have 10 days from this date right here, which is March 22nd. The net judgment, he lost, right, for $10,899. It says judgment for the plaintiff. So if he wanted to appeal, I'm assuming this is a residential property, he would have to either be low income and be able to waive the bond or pay 3 months rent or the amount of this judgment. This judgment also tells you, if you look, whether or not it's a pay and stay, right? Grant possession, yes, means it's not a pay and stay. So previously what I had talked about was if you're being sued only for rent, the court can say this is a pay and stay and you can pay your rent to stop the eviction. But here the court says grant possession, yes, so it's not a pay and stay. It would have to say grant possession, no, in order for it to be a pay and stay and to avoid that way. So this, I'm going to get out of this, but you know, this is useful not only for landlord tenant, but for everything else. And this is what I try to educate people of. We have a very open records law in Pennsylvania. So many people know about this. Landlords can access this. You know, it shows tickets, it shows basic criminal information. Like you see, you don't need a date of birth. You really don't need much information. So it's very easy to access. But on the same, you know, front, if you're a tenant, this is a great way to find out information on your court case. Does anybody have questions relating to that? No? All right. We good, Mark, or?
I have a question, Christina.
Sure. Yep.
I work for the Self-Determination Housing of Pennsylvania. How
Wonderful.
could tenants be sure that landlords aren't just utilizing this as a tool if they were doing background checks, you know, that they're not just utilizing this open portal compared to actually running a formal background check on somebody?
Well, I don't think there's any requirement that they run a formal background check. Landlords can rely on this. I mean, the only things that they can't rely on are the race-based federally protected issues. So I think many people, I think landlords oftentimes do rely on this, and that's why evictions can be so harmful for people because it's such a public record.
I guess maybe not so much on the eviction end, maybe more on the front end of tenancy. Like because you can look up criminal records, but it's also gives a lot of like the docket information, and if something wasn't resolved and they're pulling, so maybe this is a completely different conversation we can have offline. But this portal is kind of good and bad sometimes if somebody doesn't know how to read the information that's on there.
Right, yes, and so, and I think that's a good point because the eviction records probably starts right when it's filed. So even if I have a settlement or even if my client pays what's owed, the judgment is still there. So sometimes it's me educating landlords. Yes, there is a recent eviction record, but if you read the record here, the record shows that the judgment was satisfied and that the tenant paid what they owed. So sometimes advocacy for me also includes, like you're saying, trying to explain to people what these records mean.
Great, thank you so much.
You're welcome.
We have one more question that came in on chat. We have a tenant who owes us over $10,000. Can we get wages garnished?
Yes, I think it's up to 10%, provided you don't. There's some catch about them going under the federal poverty guideline. I don't know it as well because I don't represent landlords, but yes, they are garnishable under landlord-tenant judgments are garnishable. And you would have to take it to a collections attorney typically, or although some landlord-tenant attorneys do it too, so.
Okay, if there are no further questions, thank you for everyone for joining. We will be emailing you the slides from the presentation and also a link to the video. Next Wednesday, the 29th, we will be having another legal aid presentation, this on unemployment compensation and pandemic unemployment assistance. You can sign up for that on the library's website, www.phoenixvillelibrary.org. Christina, thank you for sharing your time and expertise today. Appreciate it.
Thank you.
Thanks everyone for attending and tuning in. Have a good day now.
Bye.